All right, hey everyone, Jeff here with StopThePirates.blogspot.com. Something I've been working on. When the United States declared itself a municipal corporation, it also created what is known as a Sustake Trust to function under by implementing the Federal Constitution of 1871 and incorporating the previous United States Constitutions of 1787 and 1791 as amended as bylaws. Naturally, as the grantor of the trust, this empowered the United States government to change the terms of the trust at will, as evidenced under the Federal Constitution of 1871. The 14th Amendment, the people of the United States, without their consent, were declared citizens and granted civil rights. These so-called civil rights are nothing more than mere privileges, privileges which government licenses, regulates, and can reinterpret to suit its purposes at any time for any reason. The federal corporate government also conveniently somehow forgot to disclose to the people that the term citizen, with which they have made every living and breathing inhabitant a subject, was defined in law as a vessel engaged in commerce. In 1912, when the bonds that were keeping the United States government afloat and were owned by the bankers came due, the bankers refused to refinance the debt, and the colorable martial law rule Congress was compelled to pass the Federal Reserve Act of 1913. This act surrendered constitutional authority to create control and manage the entire money supply of the United States to a handful of private, mostly foreign bankers. This placed exclusive creation and control of the money within the private, commercial, foreign, and military jurisdiction of 1861 into corporate limited liability. America converted from the United States notes to Federal Reserve notes, beginning with the passage of the Federal Reserve Act of 1913. Federal Reserve banks were incorporated in 1914 and in 1916 began to circulate their private corporate Federal Reserve notes as money alongside the nation's de jure currency, the United States notes. Whereas the United States notes were actually warehouse receipts for deposits of gold and silver in a warehouse or what they called a bank, thus representing wealth, substance, portable land, the money of sovereigns. The new fiat money, Federal Reserve notes, amounted to bills for that which was yet to be paid, i.e., for what was owed. For the new benefit of being able to carry around U.S. government debt instruments, Federal Reserve notes, in our wallets instead of gold certificates or silver certificates, we agreed to redeem the newly issued Federal Reserve notes in gold and also to pay interest for their use in gold only. Essentially, the Fed issued paper with pretty green ink on it, and we agreed to give them gold in exchange for the privilege of using it. Such was the bargain. Through paying interest to the Federal Reserve Corporation in gold, the U.S. Treasury became progressively depleted of its gold. America's gold certificates, coin, and bullion were continually shipped off to the coffers of various European banks and power elite. In 1933, when the Treasury was drained and the debt was larger than ever, a financial condition known as insolvency, President Roosevelt proclaimed the bankruptcy of the United States. Every 14th Amendment citizen of the United States was pledged as an asset to finance the Chapter 11 reorganization expenses and pay interest in perpetuity to the creditors, the Federal Reserve bankers, and the national debt, which shall not be questioned. So on March 9, 1933, Congress passed the Amendatory Act, also known as the Emergency Banking Relief Act, to the Trading with the Enemies Act, originally passed on October 6, 1917, at the time when the United States was not in a shooting war with any foreign foe and included the people of the United States as the enemy. And why would they do that? At the Conference of Governors held on March 6, 1933, the governors of the 48 states of the Union accommodated the federal bankruptcy of the United States Corporation by pledging the faith and credit of their state to the aid to the national government. Senate Document 43 of the 73rd Congress, first session, 1933, did declare that ownership of all property is in the state, and individual so-called ownership is only by virtue of government, i.e. law amounting to mere user only, and is only by virtue of a government. Law amounting to mere user only and individual use of all property is subordinate to the necessities of the United States government. Under House Joint Resolution 192 of June 5, 1933, Senate Report number 93-549, and Executive Orders 6072, 12, 6246, the Congress and President Roosevelt I shouldn't have started this. Hang on. I got the bullshit right here. I'm going to show you guys my room because it's a freaking mess. Officially declared the bankruptcy of the United States, regardless of the cause or reason. What many Americans either don't understand or don't know is, or fail to seriously grasp, is that the use of Federal Reserve note, which is not constitutional money defined under Article 1, Section 10 of the United States Constitution. The people of the United States since 1933 have not had any constitutionally lawful way to pay their debts. They therefore have not had any way to buy or own property. Slaves can't own property. The people for the benefits granted to them by the by the bankrupt corporate government discharge their debts with limited liability using Federal Reserve notes. They have surrendered, by the way of an unconscionable contract, their individual rights under the Constitution in exchange for mere privileges. A review of countless United States Supreme Court decisions since 1938, landmark case Erie Railroad versus Tompkins, clearly establishes that only the state has constitutional rights, not the people. The people have been pledged to the bankruptcy of 1933. The federal law administered in and by the United States is the private commercial law of the creditors. That, due to the bankruptcy, every citizen of the United States is pledged as an asset to support the bankruptcy, must work to pay the insurance premiums on the underwriting necessary to keep the bankrupt government in operation under Chapter 11 bankruptcy reorganization. That upon the declared bankruptcy, Americans could operate and function only through their corporate colored, state-created, all capital letters name that has now no access to sovereignty, substance rights, and standing in law. The Supreme Court also held the general universal common law no longer is accessible and in operation in the federal courts based on the 1933 bankruptcy, which placed everything into the realm of private colorable law merchant of the Federal Reserve creditors. To take this to a different level and not only explain why you pay taxes, but also why you do not own the house you live in, the car you drive, or anything else you think you've bought and paid for, etc. The state government and its creditors own it all. If you think you own your car, your home, just because you believe you paid it using those Federal Reserve notes, just like everything else you possess by permission of government, simply stop paying your taxes or the user fees, the licenses, and see just how long the government and the creditors allow you to keep it before they come and take it away from you. Stop paying your property taxes. It's not your house, it's the state's house. Or your car, stop paying your registration. I've had one taken off the street and towed it. It was a $500 car, but I mean, that's how they do it. It's their car. So how can all this really be? Why haven't you been told any of all this until now? Ignorance of the law is no excuse. Every man is deemed required to know the law. Government expects you to know the law and holds you fully accountable for doing so. Ignoring these facts will not protect you. The majority of Americans have been given a public education to teach them what the public, i.e. government creditors, want them to know. Nobody's going to teach you the information you need or the education you would have to fight your way out of this, obviously. They keep you in the dark. Any creditors, and they're only going to teach you what they want you to know. It has always has been each individual's personal responsibility, duty, and obligation to learn and know the law. So what this breaks down to is that back in 1933, when the United States went into bankruptcy, I think it was actually the third bankruptcy. Corporate bankruptcies are 70 years long. So I've gone into that in other videos, but the United States went into bankruptcy because it could no longer pay its debts. It pledged all American people themselves without their consent to the asset to keep the government afloat and operating, because the government no longer has any way to pay its debts with substance, and it was bankrupt. It lost sovereignty and standing in law outside and separate of the constitutional government to continue to function and operate. It created an artificial world consisting of artificial entities, and this was accomplished by taking everyone's proper birth given name and creating what is called a fiction in law by way of an acronym, i.e. a name written in all capital letters, the dead entity to interact with. The name written in all capital letters is not a sentient flesh blood human being, is a corporation, fiction, or deceased person. Government, as well as all corporations, including the Internal Revenue Service, cannot deal or interact with you or interact with you via your proper name given to you at birth, only through your all capital letters name. Another little tidbit of knowledge which has been conveniently kept from the people is this: when the several United States signed a treaty with Great Britain ending the Revolutionary War, it was a concession that all commerce would be regulated and contracted through British attorneys known as esquires only. This condition and concession still exists today. No attorney or lawyer in the United States of America has ever been licensed to practice law. They've exempted themselves as they are legal fiction persons. And the only admitted member to practice in private franchise club called the Bar, which is itself an acronym for the British or barrister aristocratic or accreditation regency. As such, are unregistered foreign agents, and so they are traitors. Esquire's unconstitutional title of honor and nobility equals esquires, foreign non-citizen aliens who are specifically prohibited from ever holding any elected public office of trust whatsoever. Article 1, Section 9, Clause 8 states, no title of nobility shall be granted by the United States, and no person holding any office of profit, P-R-O-F-I-T, or trust under them shall, without the consent of the Congress, accept any present employment, office, or title of any kind whatsoever from any king, prince, or foreign state. As a direct result, attorneys and lawyers cannot and do not represent you in your proper birth or given name. Attorneys and lawyers represent corporations, artificial persons, and fictions in law only. What the majority of this country failed to recognize is this: because of the bankruptcy and having been pledged as the asset of the national government's debt, this makes all citizens debtors under Chapter 11 debtors in bankruptcy, having lost their solvency, have no rights nor standing in law, and are at the mercy of the creditors. All courts today sit and operate as non-constitutional, non-Article 3 legislative tribunals, administering the bankruptcy via the statutes and or codes. All courts are Title 11 bankruptcy courts, where these statutes are in reality commercial obligations being applied for the benefit or privilege of discharging debts with limited liability of the Federal Reserve monopoly, color roll money, Federal Reserve notes, debt instruments. This means every time you end up before a court, not only do you not have any standing in law to state a claim upon which relief can be granted, you have no constitutional rights. Why is this? Because you are a debtor under a bankruptcy, and in addition to have contracted away your rights in exchange for benefits and privileges, you do not have one single shred of evidence to establish otherwise. In bankruptcy, only creditors have rights. In a nutshell, as a debtor, it is impossible for you to access constitutional rights. They are reduced to mere privileges which have to be licensed, regulated, and can be altered, amended, and privileges which are all licensed, regulated, can be altered, amended, and changed to meet whatever the particular or special needs of government for whatever whim. If taking away your home, your car, taxing your labor, or locking you up for violating any of the 60 million plus legislatively created debtor codes and statutes they have on the books today happens to meet the needs of government, it really doesn't take a rocket scientist to realize who the loser will be. All right, this is about 16 minutes, and I've got it off there, but I'm going to leave this mark. I'm going to continue on this kind of UCC information we'll get to a little more deeply into in the next video. Go to stopthepirates.blogspot.com. Thanks.